Welcome back, everyone, to our 5-part video series on the Certificates of Merit. Let's welcome back Nate here. Hi, Nate.
Thank you, Adrian. Welcome back, everyone that hopefully enjoyed our first video in this 5-video series. We talked a little bit about the history of Certificate of Merit, what it is, and a little bit about how it evolved from the 70s to today. So we're going to break it up into the next 2 videos because, as mentioned, there are 12 states currently in the United States that have in their statute or civil code a requirement for a Certificate of Merit in those professional malpractice or professional negligence cases that we talked about a little bit in the first video. So those states are, not in alphabetical order, Pennsylvania, Oregon, New Jersey, Nevada, Minnesota, Maryland, Georgia, Colorado, California, Arizona, South Carolina, and Texas.
Wow, sounds like a real interesting mix of geography. Not too many trends in terms of the regions there.
No. So if you're an attorney from one of those states, I implore you to watch the next 2 videos.
Sounds like that'd be a pretty big deal in terms of understanding the requirements for that one.
Yeah. So for no particular reason other than I was born there, I guess we will start with Pennsylvania, my home state. So the Pennsylvania Rules of Civil Procedure, coded as Section 1042.3, requires a Certificate of Merit for a party to proceed with a professional liability claim. Now, the Certificate of Merit must state that an expert has determined, quote, that the defendant, the professional that they're suing, quote, likely violated the applicable standard of care. Okay. So that's very, very important. Lawyers, you know exactly what I'm talking about when I say applicable standard of care. Each and every professional that we're talking about, whether it be a doctor, whether it be a lawyer, whether it be a surveyor, whether it be an engineer, must adhere to a certain standard of care as they are performing their chosen profession. And Pennsylvania requires in the Certificate of Merit that the expert has reviewed the claims that are going to be put forth in court, and that the defendant that is being sued, the professional, has somehow fallen below the standard of care that is required.
And that's required in the state to move forward with that case, right? Having the expert determine that?
Yes and no. The expert will opine as to whether in his or her experience and education, looking at the facts of the claim, can say whether the standard of care was met or not.
Okay.
But that's sometimes a subjective opinion.
Right. And there could be some gray area there in terms of, or a disagreement, but at least that's sort of the vetting of the claim at the beginning is in theory, having an unbiased expert in that industry to give feedback on it. That makes sense.
Exactly. And, you know, we could do a whole video series on standard of care, you know, because that's really at the heart of these types of cases for any professional that's being sued. It really comes down to, did you adhere to the standard of care? And then sometimes it becomes a battle of the experts.
Right.
But like I said, that's later in the litigation.
Right. At the beginning, I won't get too far ahead of ourselves in terms of you're getting an expert opinion at the beginning of the process and not having to wait until mid-trial to find that out.
Yeah.
Okay.
So the other interesting requirement for Pennsylvania is the Certificate of Merit must generally be filed within 60 days after the defendant files an answer or files a notice of intent to defend. Okay. Now, this is an interesting requirement because it does not require that the Certificate of Merit be filed with the original complaint. it gives more time to the plaintiff or the plaintiff's counsel to get that certificate of merit prepared and filed with the court.
That makes sense. So you're giving enough time, so you basically, people would still have a fair shot to get that certificate of merit. It wouldn't be a sort of a trick of the system to kind of rush through that. You'd still have that bonus 60 days. That makes sense. Okay.
All right, which is in comparison to our next state, which is Oregon. The Oregon statute, section 31.300, is where the certificate of merit is required. And in Oregon, the certificate must be filed with the complaint, which again is different than Pennsylvania. But again, the Oregon statute is very similar to Pennsylvania in terms of what is required in the certificate of merit. The plaintiff's attorney in the certificate must certify that the expert is licensed, knowledgeable in the subject matter that is subject to the case, and that the expert has concluded that, quote, the defendant likely failed to meet, yes, the applicable standard of care.
That makes sense. And that's the difference that you called out is you have to have that ready at the beginning of the process. And it's not you don't have that sort of a 60-day flexibility as Pennsylvania.
Correct. So we next move to New Jersey. New Jersey statute, section 2A-53A26 defines who is a licensed person under their affidavit of merit statute. So there's another little difference. In New Jersey, it's called an affidavit of merit as opposed to a certificate of merit. But again, it's the same thing, that the attorney has consulted with an expert that's knowledgeable in that subject area and believes that the professional defendant has not met the applicable standard of care. Now, in New Jersey, this affidavit of merit must be served on the defendant within 60 days after the defendant files an answer. So, taking sort of a cue from its neighboring sister state, Pennsylvania, New Jersey gives 60 days, an additional 60 days, basically, to file it. So we next go to Nevada, where Nevada statute section 40-6884, that statute states that the plaintiff's attorney must file an affidavit with the court at the same time as the first pleading, which is the complaint or petition. Much of the same requirements, that the expert with the attorney has reviewed the case facts, that the expert is competent in the relevant field, and again, that the experts concluded that there's a reasonable basis to pursue the claim based on the facts that the expert has been provided by the attorney. An interesting requirement in Nevada is the attorney must also attach a report by the expert that it spoke to, outlining the expert's resume, confirming their expertise, copies of any materials that expert has reviewed, their conclusions, and again, a statement from the expert affirming that the expert believes that there's a reasonable basis. For those of you who practice in federal court, there's a Rule 26 report, and this sounds very similar to that type of report that has to be attached to the affidavit that the attorney files.
So it's not just their feedback, but also sort of it sounds like the report has the documentation that they've reviewed all the necessary items in the case to be able to give that opinion. Is that kind of what goes into the report? Correct.
It sounds like it needs to be much more detailed than just a basic, attestation from the expert saying, yes, I've reviewed the claims here. I think there's a reasonable basis. Nevada requires a little bit more detail. What materials did you review? Basically, how did you come to that conclusion?
Yeah.
The court wants to know from the jump, so to speak. So next we look at Minnesota. In Minnesota, section 544.42 governs the certificate of merit requirement. When starting a lawsuit against a licensed professional for professional negligence, malpractice, The plaintiff's attorney must file an affidavit, which in Minnesota is known as a certificate of review, with the complaint or within 60 days of service of the complaint on the defendant.
Okay.
So Minnesota, again, like New Jersey and Pennsylvania, gives a little bit more time for the certificate of merit to be filed. We sound like broken records, but the general requirements are again the same. The attorney and the expert have reviewed the claims of the case, that the expert believes the claim has merit. Now, this goes one step further in Minnesota. Within 180 days of when the defendant files an answer, the plaintiff must serve an affidavit of expert identification, which identifies the expert, sort of like an expert disclosure for those of you who are familiar with that term. Same thing, includes a summary of the basis for the claim, and it describes the standard of care, the alleged deviation from that standard of care, and how that deviation applies within that case, and how it was the proximate reason for the damages that are claimed in the lawsuit.
Okay, so there's sort of that another layer in terms of not just the giving an opinion that there's something outside the normal realm, but also in this case, basically this is a standard of care. This is where it didn't meet that, and that's why there's damages from there. So it sounds like another layer of detail.
And now Minnesota provides in their statute that failure to serve the certificate of review within the 60 days or the expert disclosure affidavit of review that we just spoke about results in mandatory dismissal with prejudice. So attorneys will know that that means you can't bring that case again if it is dismissed with prejudice.
Gotcha.
So it is imperative for attorneys, particularly in Minnesota, to have their timelines calendared and make sure that they have consulted an expert if they are pushing one of these cases.
Okay, that makes, so do you really have to, like, if it's a larger issue, you got to make sure you have everything together at the beginning, because if it gets dismissed with prejudice, that's your shot and it's gone.
Yes,
Okay.
and you will not have a happy client. I can guarantee you. I'm not an attorney, but I've worked with plenty of attorneys. You will not have a happy client.
It sounds like a pretty reasonable response.
Yes. So lastly, for this video, we'll look at Maryland. The Maryland Code, particularly the Judicial Procedure Section 3-2C-02, is the certificate of merit requirement there in Maryland. The certificate must be filed within 90 days after the complaint is filed. So Maryland gives you 90 days to do that. Much like the other ones, the certificate must state that the professional failed to meet an applicable standard of professional care, and that the failure was the proximate cause of the plaintiff's alleged injuries. And in Maryland, if the plaintiff does not file the certificate within 90 days, if they are not granted an extension by the court again must dismiss the claim. But in Maryland, it's without prejudice, which is interesting. Maryland's a little bit more lenient. So without prejudice means the case is dismissed, but if you are prepared to meet the statutory requirements, you can bring the case again.
So in that case, you just didn't meet the criteria, so it gets dismissed, but it does not like, as you just mentioned, is not dismissed with prejudice. So it's not the only time it can be brought to trial. Okay.
Exactly. Yeah, so that looks at the first 6 states. Hopefully that was informative for everybody, and in our next video, we'll look at the remaining 6 states, which have a certificate or affidavit of merit requirement.